He obtained his Bachelor of Arts major in political science. He was a recipient of the Outstanding Student Award at the University of Negros Occidental Recoletos. He was a Rotary Foundation International Group Study Exchange Scholar to Sweden, a Fulbright Institute Fellow at the Temple University in Philadelphia, Pennsylvania, USA, a Swiss IFF Scholar at the Freiburg University in Switzerland, and a resource speaker at the 2010 ASEAN Regional Forum in Brussels, Belgium. He placed 10th at the 1997 bar examination, a Thomas More awardee in 2015, and the Rusty Dalferez Memorial Fund Award recipient only this year, 2023. Aside from these achievements, he has also authored books such as The Public International Law Bar Reviewer and Bar Exam English, published by Rex Education, and a lecturer in the MCLE for Lawyers in International Law, and a Bar Reviewer and lecturer in Public International Law and Bar Exam Techniques. He was the Executive Director of the University of St. LaSalle Law Center from 1998 till 2010 and is now the Dean of the University of St. LaSalle College of Law in Bacolod City. Ladies and gentlemen, it is my honor to present to you Dean Ralph A. Sarmiento. Good afternoon, Dean.
Good afternoon po. Can I start now?
Yes po, Dean.
Okay, let me share my screen. Okay, so good afternoon, and before I begin with my lecture proper, let me thank Rex Education and of course the Philippine Association of Law Schools PALS for making this lecture possible. So thank you very much, and of course good afternoon to everyone who is joining us in this afternoon's lecture. So my assigned topic are the frequently asked topics in public international law, and if I will still have the time, I may as well take time to lecture about some fundamental or important concepts in public international law if we still have the time later. Okay, so without much ado, let me begin. Okay, so let me begin with a cornerstone element of Philippine constitutional law, which is Article 1 on national territory under the 1987 Constitution. Now, this topic is frequently asked in the Philippine Bar, given its foundational significance in Philippine political law. So let me first examine the actual wording of Article 1. The text reads as follows: the national territory comprises the Philippine archipelago, with all the waters and islands embraced therein. And then it proceeds with all other territories over which the Philippines has sovereignty and jurisdiction, and then it talks about their domains. And then it ends with the statement about the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimension. And it is said that they form part of the internal waters of the Philippines. And this last part, this embodies or codifies what is known as the archipelagic principle, which is very important for purposes of the bar examinations. So take note, the first part talks about the Philippine archipelago. So this refers to the geographical mass that consists of the country's numerous islands. And this definition is rooted in both historical context and legal precedent. And then the islands and waters encompasses not only the landmass, but also the maritime areas, the rivers, and the lakes. And then the clause, all other territories over which the Philippines has sovereignty and jurisdiction, or jurisdiction, allows for the inclusion of territories that may not be part of the archipelago, but over which the Philippines exercises either sovereignty or control. Now, what is the importance of understanding Article 1 on the national territory? Now, this is critical for several reasons. Number one, for purposes of territorial integrity. Article 1 delineates the territorial extent of the Philippine Republic, and it serves as a basis of national integrity and sovereignty. Second, for purposes of jurisdiction, legal proceedings and law enforcement derive their territorial scope from Article 1. And then for international relations, it's also very important because it lays the groundwork for diplomatic interactions and territorial disputes. So given its significance, Article 1 is often asked in the bar examination, especially through hypothetical questions or scenarios questioning the extent of Philippine sovereignty or jurisdiction over certain areas. Now, let me turn to the archipelagic doctrine, another subject of immense importance in Philippine political law, particularly in the Philippine bar examinations. So the archipelagic doctrine refers to the legal and constitutional framework that allows a country to treat its numerous islands and waters enclosed by archipelagic baselines as a single unified unit or entity. This doctrine is embodied both in international law and Philippine law, providing the basis for the Philippines' sovereignty and jurisdiction over its archipelagic waters, as well as the airspace above and the seabed and subsoil beneath these waters. Now, the Philippine adoption of the archipelagic doctrine, as I've already mentioned previously, it's embodied in Article 1 of the 1987 Constitution. And at the same time, this is also further emphasized in Republic Act number 9522, which is known as the Philippine Archipelagic Baselines Law. Now, the archipelagic doctrine is likewise recognized under the UNCLOS, or the Universal or United Nations Convention on the Law of the Sea. And this international treaty, the UNCLOS, has been ratified by the Philippines, and it provides the framework that justifies the archipelagic doctrine and sets guidelines for its limitations or implementation. Now, what are the legal implications of this doctrine? Now, the implications for the Philippines are very profound, especially concerning the legal jurisdiction over resources and our territorial integrity. It permits the Philippines to exercise sovereignty over a vast maritime area, which is crucial given the country's geographical composition of more than 7,000 islands. Typical bar examination questions concerning the archipelagic doctrine often revolve around the legal basis, the constitutional mandate, and the practical implications to the Philippines. So it's advisable to have a nuanced understanding of the UNCLOS and the specific laws that engage with the archipelagic doctrine. Now, let me turn to another very important topic, which is the doctrine of state immunity. Now, this principle, which is also known as the principle of non-suability, at its core, it embodies the idea that the state, as a sovereign entity, cannot be sued in its own courts without its consent. The doctrine is deeply rooted in the concept of sovereignty, and it recognizing that the state possesses inherent dignity and autonomy that should be preserved. In practical terms, this principle ensures that the government can function without undue hindrance from legal actions. Now, what is the basis of this doctrine of state immunity? First, with respect to the constitutional basis, this is found in Article 16, Section 3 of the 1987 Constitution, which states that the state may not be sued without its consent. It reflects nothing less than a recognition of the sovereign character of the state and an express affirmation of the unwritten rule, effectively insulating it from the jurisdiction of courts. It is also based on the very essence of sovereignty. In the classic formulation by Justice Oliver Wendell Holmes Jr., considered to be the greatest jurist of the English-speaking world, particularly in the case of Kawawa Nakoa versus Polybank, he said, "A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends." Sometimes this doctrine is also derisively called the royal prerogative of dishonesty, because it grants the state the prerogative to defeat any legitimate claim against it by simply invoking its non-suability or by simply refusing to give its consent to be sued. Now, state immunity is not only a domestic concept, it is likewise a doctrine or a principle in international law. The shield of immunity is it also extends to foreign states. A state may not be sued in the courts of another state without its consent. And this is a necessary consequence of the principle of independence and equality of states. And this rule is derived from the principle of sovereign equality of states, which is a fundamental principle of the Community of Nations, particularly the United Nations Organization, and it is expressed in the Latin maxim, parem parem non habet imperium, or meaning to say, among equals, there can be no superior. All states, therefore, are considered to be sovereign equals, and they cannot assert jurisdiction over one another. And a contrary attitude is said to unduly vex the peace of nations. So what are the purposes of this doctrine? Number one, it safeguards the state's financial resources, ensuring that public funds are allocated to public welfare rather than being tied up in legal disputes. Second, it promotes the effective governance by shielding the government from undue disruptions caused by litigation. And third, state immunity also fosters diplomatic relations, as it prevents foreign courts from asserting jurisdiction over sovereign states. Now, you have to take note that the doctrine of state immunity is not an absolute rule. It does not say that the state may not be sued under any and all circumstances. On the contrary, the doctrine says the state may not be sued without its consent. And therefore, its clear import is that the state may be sued with its consent. So how does the state give its consent to be sued? Well, we all know that it can be given expressly. It can also be given impliedly. So there is express consent or express waiver of immunity when there is a general law waiving the immunity of the state. In the context of the Philippines, so for example, we have Act number 3083, whereby the Philippine government consented and submitted to be sued upon any money claims involving liability arising from contract, express or implied, which could serve as a basis of civil action between private parties. Consent may also be made through a special law, like in the case of Merit versus Government of the Philippine Islands. Implied consent, on the other hand, is conceded when the state itself commences litigation, thus opening itself to counterclaims, or when it enters into a contract, because in this situation, the government is deemed to have descended to the level of a private individual and to have divested itself of its sovereign immunity. Take note, however, that not all contracts entered into by the government operate as a waiver of its non-suability. Distinction must be made between one which is executed in the exercise of its sovereign function and another which is done in its proprietary capacity. Hence, technically, the state waives its immunity impliedly when it enters into a contract in its proprietary capacity, and the same is not incidental in the exercise of its sovereign functions. And this brings us to the restrictive theory of state immunity. So the doctrine of state immunity's application is often viewed through the lens of the restrictive theory. And this theory distinguishes between acts iure imperii and acts iure discontinuis. Acts iure imperii pertain to the sovereign functions of the state. On the contrary, acts iure discontinuis involve commercial or proprietary functions of the state. Under the restrictive theory of state immunity, which is followed in the Philippines, the state cannot invoke immunity from suit when it is sued in its proprietary or commercial capacity or in acts iure discontinuis. In other words, when the state engages in activities that are commercial or proprietary in nature, it is deemed to have descended to the level of an individual, and it can now be sued like any private entity. However, you have to take note that when the state engages in activities that are sovereign or governmental in nature, it retains its immunity from suit, and therefore it cannot be sued without its consent. Now, when is a suit against a public official considered to be a suit against the state? A suit against a public official is considered to be a suit against the state when the public official is sued in their official capacity for acts performed in the discharge of their public duties. In such cases, a public official is considered to be acting as an agent of the state, and the suit, therefore, is considered to be effectively against the state itself. However, you have to take note that if a public official is sued in their personal capacity for acts that are outside of the scope of their official duties, or for acts that are performed in bad faith or with malice, then the suit is not considered to be against the state. And in these cases, the public official may be held personally liable for their own actions. Now, let me turn to the incorporation clause. So the incorporation clause is another important provision of the Philippine Constitution, and it states that the Philippines adopts the generally accepted principles of international law as part of the law of the land. It serves as another cornerstone or a cornerstone for the integration of international law into Philippine law and policy. So this means that international law is automatically incorporated into the Philippine domestic law without the need of any further action on the part of the Philippine government. So it also provides the basis for the application of international law in Philippine courts. Now, the nature of the incorporation clause under Article 2, Section 2 of the 1987 Constitution is that it is both restrictive, but at the same time automatic. It is restrictive in the sense that it only covers the generally accepted principles of international law, but automatic in the sense that it does not need any further legislation or further affirmative actions on the part of the state or the government. Now, the incorporation clause generally applies to customary international law and norms which are considered to be jus cogens, rules of international law that are accepted universally or which are considered to be imperative. For other norms or principles of international law, especially those which are considered to be jus dispositivum, as distinguished from jus cogens or jus cogens norms, they may become part of Philippine domestic law through a process of transformation. So when it is a generally accepted principle consisting of customary norms or jus cogens norms, they are automatically incorporated pursuant to the incorporation clause. But for other norms, which are considered to be jus dispositivum, they need to be transformed. So we need to talk about another method, and this is known as the transformation method. So the transformation method allows international law to be converted into domestic law through a specific legislative, executive, or judicial act. With this act of transformation, international law can have force within our domestic legal system. So for example, principles of international humanitarian law under the Rome Statute of the International Criminal Court have been transformed into domestic law through Republic Act number 9851 or the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. Another example, the principles of the CEDAW or the Convention Against Elimination of All Forms of Discrimination Against Women have been transformed into domestic law via Republic Act number 9262 or the Anti-Vowsy Law. Treaties and international agreements may also be transformed into domestic law upon the ratification by the President in the exercise of his treaty-making powers and upon concurrence of at least three-fourths of all the members of the Senate pursuant to Article 7, Section 21 of the 1987 Constitution. And likewise, the Supreme Court may also transform a principle of international law to become part of domestic law when it applies the same in deciding cases. And this is known as a soft transformation. Now, let me jump to another important principle. This is the principle about the self-executing and the non-self-executing provisions of the Constitution. Generally, a provision that establishes a broad principle, often found in Article 2 of the 1987 Constitution, which is known as the Declaration on Principles and State Policies, it is usually considered to be, or typically, not self-executing. Conversely, a provision is considered to be self-executing if it is complete in itself and becomes operative without requiring supplementary or enabling legislation from Congress. A self-executing provision also supplies an adequate rule by which the right it confers may be enjoyed or protected. So even if the provision does not contain any specific remedies for the enforcement or vindication of the said right, it operates upon the principle of ubi ius, ubi remedium, which means that whenever or where there is a right, there has to be a remedy. And this legal maxim signifies that if someone's legal rights are violated, there will be a way for them to seek redress or remedy through the legal system. Another indicator of the self-executory nature of a provision is when the Constitution itself fixes the nature and the scope of the rights granted as well as the liabilities imposed by the provision. These elements can be determined through a textual examination and interpretation of the provision's terms, provided, of course, that there is no language suggesting that the matter is deferred to the legislature for further action. Now, let me turn to the principle of separation of powers, another cornerstone principle of Philippine political and constitutional law. What is separation of powers? At its core, the principle of separation of powers serves to distribute the functions of the government among its three principal branches: the executive, the legislative branch, and the judiciary. The division ensures a system of checks and balances, thus preventing a single branch from gaining disproportionate power. To achieve this purpose, the divided power must be wielded by co-equal branches of the government that are capable of independent action in exercising their respective mandates. Now, when's the principle violated? There is a violation of the principle of separation of powers when one branch unduly encroaches on the domain of another. And this encroachment can be done in two ways. Firstly, one branch may interfere impermissibly with the performance of another branch constitutionally assigned functions. And secondly, when one branch assumes a function that is more properly is entrusted to another branch. And so the principle of separation of powers is violated. Now, let's turn to the principle of balances. Now, usually, most people and even law professors talk about the distinction, talk about the principle of checks and balances, but oftentimes you don't see anyone trying to distinguish between the checks and the balances. The principle of checks is different from the balances under the principle of checks and balances. So one should be able to distinguish the checks from the balances because they are an entirely different system. The concept of balances in a constitutional framework, it refers to the structural features that inherently moderate or distribute powers among the different branches or levels of government. Checks, on the other hand, are active restraints where one branch can limit or stop another. Balance are more passive because they are built into the system's architecture, so they're embedded in the system. So this could include how terms of office are staggered, how different bodies represent different constituencies, or how power is distributed between the state and the local government units. So the idea is to create a system in which no single actor or branch can easily dominate or make unilateral decisions without consideration of the other stakeholders. Now, in the context of Philippine constitutional law and the Philippine governmental system, what are the balances that are built into the Philippine constitutional system and governmental structure? So the Philippine constitutional structure incorporates several balances, and they are aimed at distributing power and ensuring that no single entity gains an overwhelming influence over the entire republic. These features that were embedded into the constitutional system collectively form a complex web of balances that work in tandem with the principle of checks to prevent any one branch or a single branch or level of government from becoming overwhelmingly powerful. And this design helps to safeguard democratic governance, and it mitigates the risk of tyranny. First example of a balance is the existence or the observance of the principle of decentralization and devolution of powers to the local government units. The Philippine system allows for decentralization and devolution of powers to local government units through the local government code. This creates a system where not all governance decisions are made at the national level, because by empowering the local government units or the LGUs with certain legislative and administrative functions, the central or the national government's dominance is mitigated. And this mechanism provides the LGUs the latitude to address localized issues more effectively. Now, another example of a balance in our constitutional system is the existence of different terms of office for elected officials. So the Philippine Constitution stipulates varied or different terms for different elected public officials. For example, the president serves for a term of 6 years. Senators also serve for a term of 6 years, but are subject to staggered elections. And congressmen serve for 3 years. And then other public officials in the local government units also serve for 3 years. Take note, the president is not eligible for re-election, while senators and congressmen can be re-elected. So this system not only avoids abrupt changes in power, but it also ensures that voters have the opportunity to reassess their elected officials at different intervals. A third example of a balance is the existence of different constituencies. In the Philippines, elected officials represent various forms of constituencies. For instance, the president is elected by the entire nation. Senators represent the whole country. Congressmen are elected from individual legislative districts, but some are voted through or via the party list system. Local officials like mayors, governors represent the respective cities or provinces. So this setup ensures that different geographic and demographic sectors have representation in governance, thus reducing the concentration of power in only one area or district. Another balance is the existence of a bicameral Congress. The Philippine Congress is bicameral, composed of the House of Representatives and the Senate. And this arrangement provides for multiple layers of review for any proposed legislation or bill. It also encourages consensus building and deliberation, making it more difficult for a single piece of legislation to pass without thorough scrutiny from various perspectives. Another important balance is the fact that we have a constitution provided for independent constitutional commissions, particularly the COMELEC, the COA, Civil Service Commission, and likewise the Office of the Ombudsman. So these bodies operate autonomously without being under any of the three main branches of government, and thereby it provides a counterbalance to potential excesses or deficiencies in the three main branches of government. Likewise, the party list system is also designed as a form of a structural balance. It ensures that marginalized sectors have representation in the House of Representatives. So this adds another layer of balance by amplifying voices that might otherwise be drowned in the majoritarian electoral system. And lastly, to complete the balances built or embedded in the Philippine constitutional system and governmental structure, we have the system of people's initiative and referendum. So the Constitution provides that the people can directly propose and enact laws, or directly approve or reject any law or act through popular vote. And thus, it serves as a balance against potential legislative inertia, inaction, or neglect. Now, let's examine the example. Okay, so after we have discussed about the balances, now let's turn to the checks which are existing within our constitutional system. So, for example, in the table, you will see these are the checks that can be done by the executive, okay, over the legislature and then over the judiciary. For example, on the part of the executive can use the veto power, okay, over against the bills or proposed legislation from the House or from the either the House of Senate or the House of Representatives. And then the executive also exercises a form of a check through the appointment, whereby it's the president who appoints members of the judiciary, although it's from a list, short list provided by the Judicial and Bar Council. Now, the president also exercises the power of executive clemency, so he can grant pardons, commutations, reprieves, and this also operates as a form of a check against the exercise by the judiciary of its judicial functions. On the part of the legislature, over the executive, the legislature has the power of impeachment. So the House may initiate impeachment proceedings against high-ranking officials while the Senate conducts the trial. The legislature likewise has the power to confirm appointments made by the president through the Commission on Appointments. And then we also have a question hour whereby the Congress can require public officials or officials, especially from officials of the executive branch, to appear and to answer questions about their departments. And of course, whenever the president exercises his veto power, Congress may override the same if they have a 2/3 majority vote. Over the judiciary, the legislature likewise has the can check the acts or the judiciary branch through its impeachment power. It also has the budgetary power because it's the legislature that controls the appropriations, thereby affecting the judiciary's functions. And it can also override judicial decisions through the passage of corrective legislations after which can effectively negate judicial interpretations made of laws coming from Congress. And on the part of the judiciary, it's mostly about the exercise of the power of judicial review, whereby the courts or the judiciary can review and then, of course, potentially declare unconstitutional or invalid laws coming from Congress or programs being implemented by the executive branch. And in addition, of course, the judiciary also has the writ of amparo and the writ of habeas data, which can also serve as a form of a check against the executive branch. Now, let's talk about the principle of blending of powers. So we came from the principle of separation of powers, then the principle of checks and balances. Now, let's talk about the principle of blending of powers. So there is blending of powers when the Constitution requires that one branch initiates an action that must be completed or ratified by another branch to be valid and effective. So this model breaks away from a rigid understanding of the principle of separation of powers, and it allows for interdependence among the branches of government. This approach also enhances the principle of checks and balances, and it also facilitates cooperation among the branches. Examples of blending of powers under the 1987 Constitution. First, we have the appointment powers. Under Article 7, Section 16 of the 1987 Philippine Constitution, the President has the power to appoint officials. But such appointments often require confirmation by the Commission on Appointments, which is a legislative body. So the President appoints, and then Congress confirms the appointment. So it completes the process of appointment. The budgetary process, for example, it's the President who prepares the budget, and then Congress passes the necessary appropriation law. So that's also an example whereby the powers of the executive branch and the legislative branch are being blended. Impeachment, on the other hand, is also initiated by the House of Representatives, and then the impeachment process is completed by trial in the Senate, pursuant to Article 11, Section 6. And when the President is subject of impeachment, it is the Chief Justice who presides the proceedings. With respect to the treaty-making process, it is the President who negotiates and ratifies treaties, but these treaties can only become effective and binding if they are concurred by at least 2/3 of all the members of the Senate, pursuant to Article 7, Section 21 of the 1987 Constitution. Thus, a blending of powers with respect to the performance of the treaty-making process, between a blending of powers between the executive and the Senate in particular. And now this brings us to the principle of delegation of powers. This principle is, again, a logical corollary to the doctrine of separation of powers. So it is expressed in the Latin maxim potestas delegata, non delegari potest, which means that what has been delegated cannot be further delegated. And this doctrine is based on the ethical principle that once a power has been delegated, and we have to assume that all powers come from the people. So once the people have delegated the power upon, unto a particular public official, that public official will have not only a right, but also, more importantly, a duty to perform that function or that duty, that power that has been delegated to him, using his own judgment and not through the intervening mind of another. So what has been delegated by the people to a public official should not be further delegated by that public official through another person, because the trust of the people have been given to him, so he must perform that through the instrumentality of his own judgment. Now, take note, the presumption is always in favor of non-delegation. So in case of any ambiguity or vagueness in the delegation, so it must be resolved in favor of non-delegation. Because otherwise, the delegate might abdicate their duty to perform the task delegated to them if the rule were otherwise. Now, what are the tests in determining whether there is a valid delegation of legislative power? There are two accepted tests. Okay, first, we have the completeness test, and then we have the sufficient standards test. Under the completeness test, the law must be complete in all its terms and conditions when it leaves the legislature, such that when it reaches the delegate, the only thing that he will have to do is to enforce or to implement the law. Now, under the sufficient standard test, there must be adequate guidelines or stations in the law to map out the boundaries of the delegate's authority to prevent the delegation from running riot, exact words used by the Supreme Court. So both tests are intended to prevent a total transference of legislative authority to the delegate. And the delegate, of course, is not allowed to step into the shoes of the legislature and exercise a power which is essentially legislative in nature. Now, what are the exceptions to the principle of non-delegation of power with respect to the delegation of legislative powers? First, we have the delegation of emergency powers to the president, which is allowed by the Constitution itself. So this is allowed under Article 6, Section 23, Paragraph 2 of the Constitution, whereby Congress may, by law, authorize the president to exercise powers necessary during emergencies, provided, of course, that it specifies certain limits and standards for the exercise of such delegated power by the president. Then we have the tariff powers, delegation of tariff powers to the president, which is provided for in Section 28, Paragraph 2 of Article 6 of the 1987 Constitution. And of course, the scope and limitations of such a delegation of power must also be explicitly defined by Congress. And then we have delegation to the local government units. Okay, so as an exception, local government units are vested with the authority to enact ordinances within the scope of their territorial jurisdiction. There can also be delegation to administrative bodies who are given the task to implement particular legislations. And the delegation is considered to be permissible if the enabling statute offers standards to guide the actions of the delegate. So the implementing legislations that they release or they implement, it should be within the scope of implementing the enabling law which is being implemented. And then we have the doctrine of qualified political agency, which is also important for purposes of the bar examinations and also, of course, for theoretically for purposes of international law per se. So this doctrine, qualified political agency, also known as the alter ego doctrine, it postulates that the acts performed by secretaries and other officers in the executive department are by default deemed to be acts of the president himself, unless, of course, the president quickly and expressly disapproves them. The 1987 Constitution does not explicitly mention the doctrine of qualified political agency, but it is a principle derived from jurisprudence. And the doctrine emanates from the president's power of control over all executive departments, bureaus, and offices as stipulated in Article 7, Section 17 of the Constitution. Now take note, the doctrine has its own limitations. First, when there is disapproval on the part of the president, so if the president expressly disapproves an act, then it is nullified and it cannot be considered to be an act of the president himself. And second, of course, if the act of the secretary or the public official under the executive branch is ultra vires or beyond his powers or authority, or are not aligned with the existing laws, then they are also not protected by the doctrine of qualified political agency, and therefore they will not be considered to be the acts of the president himself. Now let's talk about police powers. Police power is the inherent and plenary power of the state to enact laws and regulations that promote the general welfare. Also public safety, common good, comfort of society, and many other valid objectives of police power. It is considered to be the most essential, insistent, and most illimitable power of the state. In the Philippine setting, police power has allowed the state to enact legislations that may interfere with personal liberty or property in order to promote the general welfare. Some examples of the exercise of police power in the Philippines include prescribing retention limits to landowners under the Comprehensive and Reform Law, granting discounts on medicines for senior citizens and persons with disabilities, temporary closure of Boracay to tourists, limiting the deployment of overseas contract workers to skilled workers, and regulating the exercise of certain professions that are imbued with public interests. So what are the requisites for the exercise or the valid exercise of police power? Of course, we have the lawful subject, and then we have the lawful means. So for the lawful subject, the subject of the exercise of police power must be lawful, or it must have a lawful purpose or objective. And as to the means employed must be reasonably necessary, and they must not be unduly oppressive. And take note also that the exercise of police power may sometimes clash with individual rights and freedoms. And it is therefore crucial to reconcile this with the Bill of Rights, especially with the principles of due process and the equal protection under the law. So you have to take note that any discriminatory exercise or violative exercise of police power which is in violation of the principle of or the right to due process, they may be struck down by the Supreme Court as being unconstitutional. So in case of conflict between the police power and Bill of Rights, particularly the fundamental rights which are guaranteed by Article 3 of the 1987 Constitution, so what happens? So does police power limit the Bill of Rights, or does the Bill of Rights limit the exercise of police power? Which is which? The answer is that the Bill of Rights serves to limit the exercise of police power, and it's not the other way around. The primary function of the Bill of Rights is to delineate the scope of governmental authority in order to protect individual liberties and fundamental rights from arbitrary and undue governmental intrusion. The Bill of Rights sets the boundaries that police power may not transgress, thereby safeguarding individual liberties and reinforcing the principle of limited government. The principle of limited government is a foundational principle of constitutional democracies, including the Philippines. So this principle necessitates that all forms of state power, including police power, must be exercised within constitutional limits and boundaries. Now, what are the standards of scrutiny in case of an alleged violation of the Bill of Rights? So when a governmental action based on police power is believed to encroach upon a fundamental right, the courts usually apply a strict scrutiny, which is a heightened form of judicial scrutiny. So under this standard, the onus probandi or burden of proof is on the government to establish that there is a compelling state interest which is at stake. Second, the means chosen are narrowly tailored to achieve that interest. And third, it employs the least restrictive means possible. Supreme Court or the judiciary may also apply the balancing of interest test principle. So while police power is essentially for the maintenance of public order and the general welfare, of course, it cannot be exercised in a vacuum, devoid of constitutional safeguards and standards. So the rights codified in the Bill of Rights act as a counterbalance, ensuring that the exercise of this inherent power of the state remains constrained and does not violate fundamental rights and freedoms. And so courts play a pivotal role in ensuring that the exercise of police power adheres to constitutional limits. This judicial review is fundamental to maintaining a balance, the proper balance between state authority and individual liberties. Now, what is the power of eminent domain? Excuse me. The power of eminent domain, also known as the power of expropriation, is the inherent power of the state to take private property for public use. Article 3, the Bill of Rights, Section 9 of the 1987 Constitution establishes the legal basis for this power, emphasizing just compensation or due process, or more particularly, this considered to be inherent power. And the proper function of Article 3, Section 9 is to provide a constitutional limit to the exercise of this power, that no private property shall be taken for public use without just compensation. So it provides for the right to receive just compensation in case the government or the state exercises the right, the power of expropriation. So what are the constitutional limitations? So first, we have the due process clause. Okay, it requires that no person, of course, shall be deprived of life, liberty, or property. So we focus on property without due process of law. So when there is, when the exercise of the power of eminent domain violates the due process clause, particularly because it's a deprivation of property, okay, without due process, then it can be struck down, okay, for violating the due process clause. And the second constitutional limitation is Article, as I've already mentioned, Article 3, Section 9, that provides that private property shall not be taken for public use without the payment of just compensation. Now, what are the key principles or key elements to note with respect to the exercise of the power of eminent domain? Now, take note, number one, there must be a taking of private property. So the act must involve a taking, and the taking can be either physical or regulatory. Now, so you have to make a distinction as to whether the taking or the taking is regulatory or compensable, and I'll discuss that later. Second important element is the question of public use. The property technically can all be taken by the state for purposes of some public utility or public welfare. This doctrine, however, has been expansively interpreted over the years to include not just traditional uses like roads and public buildings, but also economic development projects that broadly benefit the community. Third important element to note is the right to receive just compensation. So one important tenet of the power of eminent domain is the obligation of the state to pay just compensation to the affected property owner. And this does not merely signify a monetary exchange, but it encapsulates the idea that the compensation should be fair, it should be reasonable, and it should be sufficient. Fourth, the issue or the question of necessity. So this principle that requires necessity requires that the taking of private property must be substantially necessary for the proposed public use. Otherwise, if it is not substantially necessary, then it also becomes an unjustified or illegal taking of private property. Fifth, as I previously mentioned, due process. So this requires that the state must follow established procedures during and after the taking of the private property. So this ensures that the rights of the property owners are respected and that they have the opportunity to contest the taking or the compensation offered by the state. And of course, last but not the least, okay, least restrictive means. And this is corollary to the principle of necessity. It requires that the state should employ the means that are least restrictive or least burdensome to the property owner. So as long as the public use objective can still be achieved. Now, another important topic that you have to remember in relation to the exercise of the power of eminent domain is the distinction between regulatory taking under police power and compensable taking under the power of eminent domain. In the exercise of police power, the property involved is often considered to be noxious or detrimental to public welfare, safety, or health. So, for example, properties that violate health codes or constitute a public nuisance may be subjected to regulatory taking. So here, the primary goal is not to make use of the property for public purposes or public use, but rather to eliminate the harm or the threat to the community or to the public. As such, when the property is when the property is taken in the exercise of police power, and this is probably called regulatory taking, the property is usually either destroyed, altered, or regulated to mitigate the perceived harm. So since the property is taken out of necessity to abate a negative condition, so there is no required payment of compensation to the property owner. Now, we have to distinguish this from compensable taking in the exercise or under eminent domain. So compensable taking under eminent domain involves properties that are useful or beneficial to the public. The state takes control of these properties not because they are harmful, not because to abate a public nuisance, but because they are needed for some public use or purpose, for example, construction of public buildings, roads, or public utilities. So as the property is being taken for its utility and benefit to the public or to the community, the owner, therefore, is entitled to compensation, and thus the term compensable taking. Now, let's talk about the right to equal protection under the Equal Protection Clause, Article 3, Section 1 of the 1987 Constitution. So the Constitution states that no person, due process clause, deprived of life, liberty, or property without due process of law, and then it proceeds by saying, nor shall any person be denied the equal protection of the laws. Now, the overarching objective of the Equal Protection Clause is to safeguard individuals from the arbitrary and discriminatory action by the government. However, take note that it is imperative to recognize that the Equal Protection Clause does not require equal treatment in all instances and under all circumstances, but rather, it only mandates that those who are similarly situated must be treated alike. So it is therefore not absolute. The fundamental right to equal protection is subject to reasonable classification. So if the groupings are characterized by substantial distinctions that makes for real differences, so one class may be treated and regulated differently from the others or from another. So the classification must also be, so it requires that for that purpose, the classification must be germane to the purpose of the law, and it must apply equally to all those belonging to the affected class. Now, what are the tests or standards of review that are applied by the Supreme Court when laws are challenged or for allegedly infringing upon the Equal Protection Clause? First, we have the rational review or rational basis review. Then we have the intermediate scrutiny, and then we have the strict scrutiny test. Now, turning to the rational basis review test. So, as a rule, a law subject to the equal protection analysis must meet the rational basis test. So, under this test, the law is upheld if it is rationally related to some legitimate governmental objective. So, this is usually applied in classifications based on age, economic status, disability, and other social and economic regulations. In this test, the onus probandi is on the party questioning the validity of the law, invoking the Equal Protection Clause. And then we have the second test known as the intermediate scrutiny test. So an intermediate level, so this is sort of between the rational basis test and the strict scrutiny test. And this exists for quasi-suspect classifications like gender and gender identity, where the law must serve an important governmental objective, and it must be substantially related to achieving that objective. So in these cases, the onus probandi is on the government. And then, of course, we have the strict scrutiny test. And this applies to suspect classifications such as race, ethnicity, color, religion, or when fundamental rights like voting or the Bill of Rights are involved. In this test, the onus probandi is on the government to show that the law serves a compelling state interest that is narrowly tailored to achieve that particular interest. Now, let's talk about freedom of expression protected under Section 4 of the Bill of Rights. So the section states that no law shall be passed abridging freedom of speech, expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. So this provision guarantees the right to freedom of expression, which includes not only the right to speak and freely or to write freely, but it also includes the right to receive information and ideas. This extends not only to utterances, but also to other forms of nonverbal expressions, such as art, music, and symbolic expressions like flag burning and wearing armbands as a form of political protest. There are two aspects to freedom of expression. So first is, in order to give fullest protection for the, to allow people the fullest enjoyment to freedom of expression, the exercise or the enjoyment of freedom of expression must be free from prior restraint or censorship. And at the same time, there must be freedom, or it must be free from subsequent punishment. So first, we have freedom from prior restraint. So this refers to the prohibition against governmental actions that suppress speech or other forms of expression before they occur. So it's a form of censorship. Okay. Now, why is this important? Prior restraint or censorship causes a chilling effect on free speech. Thereby, it stifles public discourse and democratic discussion. Now, what are the exceptions to this? Okay, there are, based on our jurisprudence, based on Philippine jurisprudence, prior restraint may be considered valid, okay, under certain conditions in the following instances, like movies and television censorship, pornography, false or misleading commercial statements, advocacy of imminent lawless actions, danger to national security, and the sub judice rule. And then to complete freedom of expression, okay, we need this aspect of freedom from subsequent punishment. So this principle dictates that individuals cannot be penalized after expressing their views unless those expressions fall under legally established exceptions. Now, take note that these two aspects play a complementary role. Freedom from prior restraint ensures that the speech or expression can occur and that people can express their thoughts and let their ideas out. On the other hand, freedom from subsequent punishment ensures that there will be no adverse consequences following the expression or the exercise of the freedom of expression. So this proceeds from the principle that no person can be punished for the exercise or enjoyment of a fundamental right or freedom. Now, let me talk about certain important concepts in relation to freedom of expression. First is the concept of marketplace of ideas. This principle asserts that the truth will emerge, especially political truth, will emerge from the competition of ideas in a free, transparent public discourse. It posits that the free expression can contribute to the discovery of truth. And in the words of Justice Oliver Wendell Holmes Jr., in his dissenting opinion in Abrams versus United States, he said that the best test of truth is the power of the thought or the idea to get itself accepted in the competition of the market. Another important concept is the clear and present danger test. Again, Justice Oliver Wendell Holmes Jr. formulated the clear and present danger test in his 1999 decision in Sank versus United States. And this rule, or clear and present danger rule or doctrine, now serves as the gold standard in determining when speech can be lawfully limited or punished. So Justice Holmes explained that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that will bring about the substantive evils that Congress has the right to prevent. So take note of the keywords clear, present, and substantive evils that the state has the right to prevent. Now, another important concept is you need to distinguish between content-based regulations and content-neutral regulations. Content-based restraint or censorship refers to restrictions based on the subject matter of the utterance or speech. A content-based regulation bears a heavy presumption of invalidity and is measured against the clear and present danger test. So the latter will pass constitutional muster only if justified by a compelling reason and the restrictions imposed are neither overbroad nor vague. And then we have content-neutral regulations. So in contrast, these regulations includes controls that controls merely the incidents of the speech, such as the time, the place, or the manner of the expression or the speech. And these restrictions on speech, which are considered to be content neutral, are subject to what is known as the O'Brien test. Okay, so what is the O'Brien test? This test is applied to content neutral regulations and serves as a guide for assessing the constitutionality of TPM restrictions on speech, or time, place, and manner restrictions on speech. So the test was formulated to determine whether governmental regulation that impacts expressive conduct can be justified. So the O'Brien test is a four-pronged test. So the regulation of time, place, and manner of speech is justified if number one, so all of these four requisites have to concur. Number one, the law is within the constitutional power of the government. The law furthers an important or substantial governmental interest. The governmental interest is unrelated to the suppression of free expression. And the incidental restriction on speech or expression is no greater than that which is essential to the furtherance of that particular interest. So that is the O'Brien tests. And then let's turn to freedom of religion, another frequently asked topics in political law. Freedom of religion means that every person has the right to choose their own religion, to practice it, and to change it if they wish. The government is not allowed to establish an official state religion or to discriminate against any religion. Moreover, no one can be required to pass a religious test in order to exercise a civil or political right. These rights are guaranteed by Section 5 of the Bill of Rights, which can be dissected into three clauses. First, we have the non-establishment clause, and then we have the free exercise clause, and we have the no religious test clause. The non-establishment clause prohibits government from promoting or favoring one religion over another. In the Philippine context, this constitutional mandate ensures that the state remains neutral in matters of religion. On the other hand, the free exercise clause protects an individual's right to practice their religion within without governmental interference. One such landmark case with respect to the free exercise clause is the case of Ebralinag versus the Division Superintendent of Schools of Cebu, where the Supreme Court held that Jehovah's Witnesses could not be expelled from school for refusing to salute the flag, sing the national anthem, or to recite the patriotic pledge. This case shows how far the judiciary will go to protect free exercise rights, even against seemingly neutral laws. Another important principle is the principle of separation of church and state. So this principle is enshrined in Article 2, Section 6 of the Constitution, which states that the separation of church and state shall be inviolable. Justice Isagani Cruz explained that the rationale of the principle of separation of church and state is summed up in the saying that strong fences make good neighbors. So the idea is to delineate boundaries between two institutions and thus avoid encroachments by one against the other because of a misunderstanding of the limits of their respective exclusive jurisdictions. The demarcation line calls on the entities to render unto Caesar the things that are Caesar's, and to render unto God the things which are God's. Now, what are the tests used in determining the validity of laws that impact or affect religious freedom? Now, insofar as the non-establishment clause is concerned, what is usually applied is the three-pronged test developed by the U.S. Supreme Court in the case of Lemon versus Kurtzman, and this test is also known as the Lemon test. And this is usually used to determine whether a law or a governmental action violates the non-establishment clause, which prohibits the government from making a law respecting an establishment of religion. Now, the three prongs of the Lemon test are as follows. First, there must be a secular purpose. And this means that the challenged law or governmental action must have an objectively secular purpose. Second, there must be a neutral effect. And this means that the principal or primary effect of the challenged law or governmental action must be one that neither advances nor inhibits religion. And third, there must be no excessive entanglement between religion and the state. So the challenged law or governmental action must not result in any excessive entanglement with religion. Now, for the strict scrutiny, so insofar as the free exercise clause is concerned, as a rule, we usually apply the strict scrutiny test, okay, when a law burdens religious exercise. So the test requires that the law must be narrowly tailored to serve a compelling governmental interest. And then we have the concept of benevolent neutrality. So in the Philippines, we have this very important case, Estrada versus Escritor, whereby the Philippine Supreme Court articulated the benevolent neutrality approach that allows accommodation of religion under certain conditions. So the benevolent neutrality approach or accommodation diverges from the strict neutrality rule by allowing some levels of accommodation between the state and religion. So it means that when religion is looked upon, while religion is looked upon with benevolence and not, religion must be looked upon with benevolence, but not hostility. So benevolent neutrality allows accommodation of religion, okay, or accommodation of governmental policies that take religion specifically into account, not to promote government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. So their purpose or effect is to remove a burden on or to facilitate the exercise of a person's or an institution's religion. So in the case of Estrada versus Escritor, the Supreme Court laid down a two-pronged test to determine the constitutionality of religious exercise. First, there must be sincerity of religious belief. So this requires that there must be an examination of whether the belief that is claimed in connection with the free exercise clause is sincerely held and is religious in nature. And second, compelling state interest. So this considers whether there is a compelling state interest to regulate the practice of religion in question, and if so, whether the regulation is the least restrictive means to achieve the state's objective. Now let's turn to our Section 2 of the Bill of Rights on the clause on the searches and seizures. Okay, so with respect to Article 3, Section 2, so what rights are protected by this particular provision of the Constitution? So Section 2 of the Bill of Rights is one of the constitutional provision that actually protects the right to privacy. And this is considered to be, of course, a very important fundamental right. To be more specific, Section 2 protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for whatever purpose. And this protection serves as a safeguard against governmental intrusion into the private lives of individuals. So Article 3, Section 2 of the Constitution states that this right shall be inviolable, and that no search warrant or warrant of arrest shall issue except upon probable cause. So take note, there is no blanket prohibition against all searches and seizures. Okay? Rather, the clause operates only to prohibit searches and seizures which are considered to be unreasonable. So when is a search or seizure considered to be unreasonable? In the context of Section 2 of the Bill of Rights. Okay, so a search is considered to be unreasonable if it is made without a warrant, if the warrant is invalid or issued invalidly, or when the search or seizure is without a warrant and it is not one of the instances where a valid warrantless search can be made. Now, what is the warrant rule? A search warrant or a warrant of arrest shall be issued, okay, pursuant to Section 2 of the Bill of Rights, only upon probable cause, which must be determined personally by the judge. And note that the necessity of personal determination by the judge, okay, which is a safeguard against arbitrary invasions of privacy and freedom. But take note, this personal determination has been interpreted by the Supreme Court as merely underscoring the personal responsibility of the judge in the determination of probable cause. So, while the Constitution states that probable cause must be determined personally by the judge after examination under oath of the complainant and the witnesses they may produce, it is not mandatory for the judge with respect to, for example, to the issuance of a warrant of arrest to have personally examined or met the complainant and the witnesses, but you have to distinguish, okay, that there is a different rule with respect to searches and seizure. With respect to searches and seizure, jurisprudence has established that there must be a personal determination, and not only that, the judge has to ask there must be searching questions on answers on the applicant and the witnesses he may produce. So take note also that the warrant must also particularly describe the place to be searched and the persons or things to be seized, meaning to say there must be a compliance with the rule on descriptio personae. There must be sufficient description of the place and the place and the things to be searched or the things to be seized, and as well as the person to be arrested. And take note also of the exclusionary rule. Okay, so under paragraph 2 of Section 3 of the Bill of Rights, it states that any evidence obtained in violation of Section 2, okay, or the provision on searches and seizure, it shall be inadmissible for any purpose and in any proceeding. And this is also known as the fruit of the poisonous tree doctrine. Now, as we have mentioned, the Bill of Rights does not prohibit or does not give or it does not provide a blanket prohibition on searches or warrantless searches. Okay, so warrantless searches can be considered to be valid under certain circumstances, and these have been established by jurisprudence. So, for example, when there is a consented search, okay, which is voluntary and made without coercion. When the search is incidental to a lawful arrest, law enforcement may conduct a search of the arrested individual's person and his immediate surrounding. When there is a search under the plain view doctrine, for example, an officer sees evidence or contrabands in plain view where he has the right to be, so he may seize the evidence without a warrant. There can also be a valid warrantless search of a moving vehicle. So due to the mobile nature of the vehicle, so a warrant is not strictly necessary if there is a probable cause for the search of a moving vehicle. And then, of course, jurisprudence also developed the stop and frisk rule, so there can be a cursory search for weapons based on reasonable grounds. There can also be regulatory searches without the need of a warrant, and these can include searches at airports, border control points, as well as inspection of buildings and other premises for the enforcement of, let's say, fire, sanitary, and other building regulations and other regulations for health and safety. Take note also of another important doctrine, the abandoned property doctrine, that when the property is voluntarily discarded or abandoned by an individual, okay, it loses any reasonable expectation of privacy, and it thus permits law enforcement to seize it or to search for it without a warrant. And then we have the open fields doctrine. So in contrast to homes and buildings, open fields do not enjoy the same level of constitutional protection. So there is no reasonable expectation of privacy in open fields. So law enforcement can enter and search open fields without a warrant. And lastly, we have exigent circumstances, whereby when there is a situation where obtaining a warrant would be impractical, such as when there is an immediate threat to public safety, so there can be a warrantless search under these circumstances. Now, let's talk about the important powers of Congress. First, Congress has plenary legislative powers pursuant to Article 6, Section 1 of the Constitution. So legislative power has been vested in Congress. But you have to take note that the power is says, except to the extent reserved to the people by the provisions on initiative and referendum. And then another important power is the power of the purse, or the power of appropriation. So this refers to the exclusive authority of Congress to appropriate funds for governmental expenditure. Congress also has the power of taxation. So it has the power to levy taxes, duties, imposts, and excises, which is inherent, and it does not require an express grant from the Constitution. Congress also has the power of legislative investigation, or to conduct inquiries in aid of legislation, okay, pursuant to Article 6, Section 21 of the Constitution. And under Article 6, Section 23, Congress, by a vote of 2/3 of both houses in joint session assembled, it also has the power to declare the existence of a state of war. Now, aside from its legislative powers, Congress has also been vested by the Constitution with non-legislative powers. First, the power of impeachment. Congress has the authority to initiate and to conduct impeachment proceedings. So the House of Representatives has the power to initiate the proceedings, while the Senate acts as the impeachment court. Confirmation of appointments. The Commission on Appointments consists of members from the Senate and from the House, and they have the power to confirm certain appointments made by the President, such as cabinet ministers, ambassadors, other public ministers, and the heads of constitutional commissions. The power to concur in treaties. The Senate has the power to concur with treaties and international agreements entered into and ratified by the President as mandated by Article 7, Section 21 of the Constitution. Congress also has the power to declare the existence of a state of war, as already mentioned. Congress also has the power to revoke the declaration of martial law or the suspension of the privilege of the writ of habeas corpus. And this is pursuant to Article 7, Section 18 of the Constitution. Congress also has the power to override the presidential veto. And as also mentioned, Congress also has the power of legislative inquiry. And Congress also has the power to propose amendments or revisions to the Constitution, pursuant to Article 17 of the Constitution. Congress also has electoral tribunals, both from the House of Representatives and then the Senate. And these electoral tribunals, they settle electoral disputes concerning the members of the respective houses. Congress also has the power to canvass the presidential and vice presidential votes. Congress also has the power to decide presidential election in case of a tie or a dispute. And Congress also has the exclusive power to grant franchises for public utilities and similar services. Now let's focus on the veto power limitations on the powers of Congress. First, we have substantive limitations. Okay, for the substantive limitations, we have the Bill of Rights. So Congress cannot enact laws that infringe upon civil liberties or fundamental freedoms enshrined or guaranteed in the Bill of Rights. Second, we have the non-delegation principle, whereby legislative power must be exercised by Congress and cannot be delegated except in cases outlined by law and jurisprudence, okay, as previously mentioned, okay, such as delegation to local governments and delegation to the president, in cases of emergency powers or tariff powers to the president. There is also a substantive limitation provided by the Constitution, okay, found in Article 6, Section 31, whereby Congress is prohibited from granting titles of royalty or nobility. Now, aside from the substantive limitations provided under the Constitution, there are also procedural limitations also provided by the Constitution. First, we have the one bill, one subject rule. So according to Article 6, Section 26, Paragraph 1, every bill shall embrace only one subject, which shall be expressed in its title. So this is to preclude the practice of riders or rider provisions that are irrelevant to the bill's main subject. Second is the requirement that the title must be sufficient. So the title of the bill should be comprehensive enough to include all the provisions of the law so that members of Congress and the public can be properly apprised as to its nature, the scope, and the consequences of the implementation of the law. There are also bills that must originate exclusively from the House of Representatives, and this is based on Article 6, Section 24, with respect to all appropriation, revenue, and tariff bills, which are required to originate exclusively from the House of Representatives. There's also another procedural rule on that requires 3 readings on separate days, and this is found in Section 26, Paragraph 2 of Article 6, which requires that a bill must pass 3 readings on separate days, and this ensures ample time for deliberation and scrutiny of proposed bills or proposed legislations. And then we also have the bicameral conference committee. If the House and the Senate pass different versions of a bill, so there will be a bicameral conference committee that will be formed to reconcile conflicting provisions. So the reconciled version must then be ratified by both houses. Now let's talk about the different vetoes, okay, in our constitutional system. First, of course, we have the presidential veto. Upon receipt of the bill, okay, the enrolled bill, the president has the option to either sign the bill and then it becomes a law. So, or the president can also exercise his veto power and then veto the law. So if vetoed, Congress may override this veto by a 2/3 vote of all its members. And then we have the concept of packet veto, and this is based on Article 6, Section 27 of the Constitution. So if the president takes no action on a bill for 30 days, while Congress is in adjournment, okay, so this principle of packet veto, while allowed in other jurisdictions, so this kind of veto is not allowed under Philippine law. So under Philippine law, because of presidential inaction, okay, 30 days after receiving the enrolled bill coming from Congress, so the bill automatically lapses and becomes a law through presidential inaction. And then we have the principle of item veto found in Section 27, Paragraph 2 of Article 6. So the president is allowed to veto particular items in an appropriation, revenue, or tariff bills without affecting the entire legislation. And then there's also another concept of veto, which is also not allowed in Philippine jurisdiction. Okay, so this is the concept of legislative veto, or sometimes known as the one-house veto. So legislative veto is a statutory provision requiring the president or an administrative agency to present the proposed implementing rules or regulations of a law to Congress which by itself or through a committee formed by it retains a right or a power to approve or disapprove such regulations before they take effect. It is in the form of a congressional oversight committee, and therefore it is not allowed under Philippine law because it radically changes the design or structure of the Constitution's diagram of power, as it entrusts to Congress a direct role or it allows Congress to intervene in the enforcement or the implementation of the law, which are properly the province of the executive branch. Okay, so you have to take note that there is no legislative veto in the Philippines, and likewise, there is also no pocket veto that is allowed under Philippine law. Now, let's talk about the enrolled bill theory. So what is this theory? So once a bill is enrolled, it is presumed to have been regularly passed by the legislative department. So the enrolled bill is considered to be a conclusive proof of the bill's due enactment. Now, in case of conflict between the enrolled bill and the legislative journal, so which shall prevail? Excuse me. In the context of Philippine law, when there is a conflict between the enrolled bill and the legislative journal, the enrolled bill, as a rule, generally prevails. So this principle is rooted in the enrolled bill theory, okay? And it says that a bill signed by the Speaker of the House and the Senate President and approved by the President is conclusive proof of its proper enactment. So the enrolled bill serves as a formal, final document that represents the legislative will, and it is assumed to be an authentic act of the legislative body. So courts usually refrain from looking beyond or outside of the confines of the enrolled bill to avoid undue interference in the legislative process, thereby respecting the doctrine of separation of powers. Take note, however, that for matters specifically required by the Constitution to be stated on the legislative journal, then the legislative journal will prevail. Okay, so take note, in all other matters, okay, not required to be stated on the legislative journal, then the enrolled bill as a rule prevails. Okay, so the legislative journal will only prevail over the enrolled bill only in matters that are required specifically by the Constitution to be stated on the legislative journal. Now, the military powers of the President. Article 7, Section 18 of the 1987 Constitution outlines the military powers of the President. So essentially, the President serves in a triple capacity. He is the head of state, the head of government, and at the same time, the commander-in-chief of the armed forces of the Philippines. So Article 7, Section 18 provides certain specific powers. Particularly, first, we have the calling out power. The President shall be the commander-in-chief of the armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. The President also has martial law powers in case of invasion or rebellion. And take note, it must be when public safety requires it. He may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. And of course, the President also has the power to suspend the privilege of the writ of habeas corpus. So, and this can be made alongside with the power to declare martial law. Now, what are the important safeguards against the President's exercise of his martial law powers? The 1987 Constitution provides several safeguards against the abuse or possible abuse of the President's power to declare martial law. Okay, so this includes, number one, the power of judicial review. So Supreme Court may review in an appropriate proceedings filed by any citizen the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. Second, there must be congressional oversight. Within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus, the President is mandated to submit a report either in person or in writing to Congress, and Congress, voting jointly by a vote of at least a majority of all its members in regular or in special session, may revoke. Okay, it may revoke such proclamation or suspension, and such revocation of the proclamation or suspension shall not be set aside by the President. And third, there is also a duration limit. The duration of martial law suspension, the privilege of the writ of habeas corpus shall not exceed 60 days, following which it shall be lifted unless extended by Congress. Okay, so these measures ensure that the immense power of martial law cannot be abused by the President. Now, these are the distinctions between the power of judicial review and the congressional power to revoke the declaration of martial law or the suspension of the privilege of the writ of habeas corpus, okay, with respect to the exercise of the martial law powers of the President. So take note, the judicial power review is passive. So Supreme Court cannot do anything with it unless its power of judicial review is invoked through the initiation by a citizen, okay, by filing an appropriate proceeding, contesting or challenging or questioning the sufficiency of the factual basis of the declaration of martial law. Okay? But with respect to the congressional power to revoke, such is automatic, and it can be initiated by the Congress itself at any time after the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. Now, with respect to the scope of review, the power of judicial review of the Supreme Court is limited only to the data available to the President at or before the time of the declaration of martial law. Meaning to say, the court cannot conduct an independent investigation beyond the pleadings. So it has to limit its analysis only based on the pleadings. On the other hand, Congress can consider both prior and supervening events. And in fact, it can also probe deeper into the accuracy of the facts presented in the pleadings. As to the outcome, the Supreme Court can nullify the presidential proclamation if found to lack sufficient factual basis. On the other hand, Congress can revoke the presidential proclamation, and such revocation cannot be set aside by the President. Now, take note, the power of judicial review, when exercised in relation to the martial law powers of the President, this is independent of Congress's power to revoke. And at the same time, Congress's power to revoke is also considered to be independent of the Supreme Court's power to review. And now, as to the aim, of course, when you invoke the power of judicial review with respect to the exercise of military powers or martial law powers, the aim is the nullification of the presidential proclamation based on legal scrutiny. On the part of the congressional power to revoke, the aim is nullification or extension of the presidential proclamation based on both factual and policy considerations, meaning to say it's not limited to legal basis or scrutiny. Now let's turn to the power of judicial review. Okay, so this is another fundamental concept in political law or constitutional law. Okay, so for the Supreme Court to exercise its power of judicial review, there are 4 important requisites. First, there must be an actual case or controversy. Okay, so this is a foundational requirement stipulating that there must be an existing dispute between parties who are legally opposed to each other. Means say there must be a contrariety of legal rights between the two. Second, there must be a proper party with locus standi. So the legal standing of the petitioner, okay, and this indicates that the individual must have a personal and substantial interest in the case. Either he must have suffered a direct injury or he was directly affected, or he is in imminent danger of being affected by the implementation of the law. Third, the constitutional question must be raised at the earliest opportunity. The issue of constitutionality should not be a mere afterthought. It should be raised as soon as possible in the proceedings. So delaying the raising of the constitutional question will normally result in the dismissal of the petition invoking the power of judicial review. Fourth, the constitutional question is the lis mota of the case, meaning say the constitutional issue must be critical and necessary to the resolution of the case. It should be the pivot on which the entire controversy turns. Otherwise, the court can simply dismiss the case invoking the principle or the doctrine of avoidance. So if they can dispose of the case on some other grounds, as a rule, the Supreme Court will avoid this deciding the constitutional question raised. Now, what are the limitations on the power of judicial review? First, we have the doctrine of political questions. So when the subject matter is a political question, therefore it is non-justiciable. So it either belongs to the wisdom of the legislative or executive branch or the political branches of government, or it is a matter that is to be decided by the people directly. So when the petition raises a political question, okay, then it is considered to be non-justiciable, and therefore it cannot result in it cannot engage the exercise by the Supreme Court of its power of judicial review. And then we have the doctrine of operative fact. Unconstitutional laws may have effects that become irreversible, and therefore these effects are usually respected to an extent when they are reasonable. But of course, as a rule, the effect of the declaration of unconstitutionality is the law becomes null. Okay, the law becomes invalid. Okay, but sometimes under the doctrine of operative fact, we have to recognize that prior to the declaration of unconstitutionality, the law had effect. Okay, people had been affected by it. People had gained some vested rights before its declaration of unconstitutionality. So pursuant to the doctrine of operative fact, those things must be properly respected, okay, within constitutional bounds and limitations. Now, another important principle that you must remember is the distinction between a facial challenge and an as-applied challenge. Now, these are legal mechanisms employed to contest the constitutionality of statutes or regulations. So a facial challenge is an assertion that the statute or law is unconstitutional on its face, that is in every scenario and for every individual or group of people. It questions the validity of the law itself on its face, contending that the law cannot be constitutionally applied under any and all circumstances. Therefore, if a facial challenge is successful, the effect is that the law itself is declared unconstitutional on its face, and that is in its entirety. An as-applied challenge, on the other hand, challenges only a specific application of a law. It does not attack the law itself or as a whole or on its face, but it argues that the law is unconstitutional as applied to a particular case or to a particular group of individuals or entities. Examples of facial challenges are petitions based on the overbreadth or the void for vagueness rule. And an example of an as-applied challenge is a challenge on a law that is allegedly discriminatory against particular individuals or groups, invoking the Equal Protection Clause. Now, another important concept is the principle of mootness. When is an action considered moot, and thereby preventing the exercise of the power of judicial review? An action is considered moot when it no longer presents a justiciable controversy because the issues involved have become academic or dead, or when the matter in dispute has already been resolved, and hence one is not entitled to judicial intervention unless the issue is likely to be raised again by the parties. So there is nothing more or nothing left for the court to resolve, as the determination thereof has already been overtaken by subsequent or supervening events. Now, what are the exceptions to the mootness doctrine? So there are recognized exceptions to the rule, meaning to say that when the court has seen fit to decide cases which would otherwise be considered already as moot and academic. So there are requisites for this. So first, there must be a grave violation of the Constitution. Second, the exceptional character of the situation and the paramount public interests, okay, that are involved in the controversy. And third, the constitutional question raised requires formulation of controlling principles to guide the bench, the bar, and the public. And fourth, the case or the issue is capable of repetition, yet evading review. Okay, so take note of these 4 requirements. Now let's talk about the remedies against election results. Okay, so fundamentally, after the election, there are basically 4 possible remedies that people can employ, either the candidates or the non-candidates. Now, so we have the failure declaration of a failure of elections. We have a pre-proclamation controversy. We have the filing of an election protest, and there can also be a petition for quo warranto. As to jurisdiction, failure of election is within the jurisdiction of the COMELEC. Likewise, for pre-proclamation controversies, they are also in the jurisdiction of the COMELEC. For election protests, it varies depending on the office. So, for example, it can be in the electoral tribunals. It can also be in the courts. For the quo warranto, likewise, it varies depending on the position involved. For the scope, with respect to failure of elections, circumstances, okay, what is the scope? Okay, we refer to the circumstances making the election impossible or leading to a failure to elect. In a pre-proclamation controversy, it must deal with issues before proclamation. Okay, this includes illegal composition of the board and irregularities in the returns. And with respect to election protest, these are post-election issues affecting the vote count. For example, when there is fraud or when there is irregularity in the counting. And with respect to the petition for quo warranto, it's also a post-election issue, but instead of the voting or instead of the canvassing or the returns, the issue here is related to the to questions of eligibility and qualifications of the winner. Now, with respect to the time period for the filing of cases, failure of elections immediately after the occurrence of the alleged events leading to the failure of election. Pre-proclamation controversy, as its name implies, it must be filed before proclamation of the winner. An election protest is filed after proclamation of the winner, and a quo warranto petition must be filed within 10 days after proclamation of the winner. Now, who can file this particular election remedies? With respect to failure of elections, any registered voter or participant in the election may file, okay, for failure of elections. In a pre-proclamation controversy, this is limited only to candidates or registered political parties or coalitions. As to election protest, a candidate, okay, this is only a candidate who has filed a certificate of candidacy and who has been voted for in the same office. And with respect to quo warranto, it can be any voter. As to grounds, with respect to failure of elections, these are as provided under BP Bilang 881. Okay, we have, for example, force majeure, violence, terrorism, fraud, or other analogous cases which resulted in the failure to vote. Okay. For pre-proclamation controversies, these are also found in the election code. For election protest, it can be on grounds of fraud or irregularities in the casting or in the counting of the ballots. Now, for quo warranto, it's either on the ground of disloyalty or on the ground of ineligibility or lack of qualification to hold the public office. For the procedure, a failure of elections is filed with the COMELEC. For pre-proclamation controversy, it is the issue must first be raised before the Board of Canvassers, and then it can be with the COMELEC. For the election protest, it has to be filed with the appropriate tribunal or court. And with the co-warrant of petition, it must also be filed with the appropriate tribunal or court. Now, what is the result in a failure of election? It results in a declaration of failure of elections, and this will lead to the holding of new elections or other remedies as may be appropriate. For pre-proclamation controversy, so it can lead to the corrections prior to the proclamation. And for election protest, the protestee may be unseated, however, and the protestant may be installed. For quo warranto, the respondent may be unseated, but the petitioner may or may not be installed, depending upon the circumstances. For the nature of the action, a failure of election is an extraordinary remedy to declare an election null and void. A pre-proclamation controversy contests, it contests related to pre-proclamation issues. Election protest, it's a contest between the winning and the defeated candidates. Okay, now a co-warranto, on the other hand, is not a contest, but it's a proceeding to unseat the ineligible candidate. Now, for the burden of proof, it's all the same. The burden of proof is on the person, the petitioner, raising the issue or filing the petition or raising the contest. Now, let's turn to important concepts in public international law. First, let's talk about the sources of international law. Okay, so for the sources, our authority is Article 38 of the Statute of the International Court of Justice. So this article describes the sources that the court may use in resolving disputes, involving international law. So these sources may involve international conventions or treaties, international customs, general principles of law, judicial decisions, and also academic writings or opinions of the most highly qualified publicists of the various nations. International conventions, it says, Article 38 says whether general or particular, and they must establish rules that are expressly recognized by the contesting parties. Means say we are applying the positivist theory that international law may only be binding upon a state if the state gives consent to be bound by certain principles of international law, particularly with respect to treaties and conventions. And you have to take note, for example, the United States had a different approach. It's a very, very positivist in nature. Like in the Paquete-Habana case, Supreme Court of the United States declared that international law exists only insofar as the U.S. or the United States recognizes it. So if a state does not recognize the existence of a particular rule of international law, meaning say it has not given its consent to be bound by those particular rules, then under the positivist theory of international law, then it cannot be bound by those rules. Second, we have international customs as the second source of public international law. So international customs are considered to be evidence of a general practice accepted as law. So here there must be the concurrence of two elements. You have to establish the elements of state practice. There must be a continuous, consistent practice among states, and there must be opinio juris under the principle of opinio juris sibi necessitatis, meaning say the states engaged in that particular practice because of their belief in the juridical necessity of that practice. They believe that it is a law, and therefore they believe that as a law it is binding upon them. And then we have general principles of law, which are recognized by the civilized nations. So for example of these general principles of law are the principles of pacta sunt servanda, the principle of res judicata, and the international standards on due process. And then Article 38, second paragraph, also provides for subsidiary means in the determination of rules of international law. So it talks about, it says that subject to the provisions of Article 59, and Article 59 contains the res inter alios acta rule, meaning say judicial decisions, shall only apply to the parties to a particular case. So what are the subsidiary means in the determination of the rules of international law? We have judicial decisions, okay? And then we have the teachings of the most highly qualified publicists of the various nations. For example, Hugo Grotius, considered to be the father of international law. Lassa Francis Oppenheim, Hertz Lauterpacht, Hans Kelsen. Okay, so these can be considered, their writings can be considered as subsidiary means in the determination of rules of law. Now take note, judicial decisions and the teachings of the most highly qualified publicists of the various nations, these are not considered to be sources of international law. So technically, we only have three sources of international law. We have international conventions, we have international customs, and general principles of law. And okay, judicial decisions and opinions of the most highly qualified publicists of the various nations are only considered to be subsidiary means in the determination of rules of international law. Okay, so we can use them to determine if indeed a rule of international law exists. So judicial decisions and the teachings of the most highly qualified publicists should always point towards the existence, okay, of the sources of international law, of either international conventions, international customs, or general principles of law. Now, let's try to understand what happens in case of a conflict between international law and domestic law. Okay, so in case of a conflict between international and domestic law, how do we resolve the conflict? Or which shall prevail? Okay, so to answer the question, let us first take into account several concepts in order to understand the context of the question. First, we have to distinguish between the monist and the dualist system in international practice and within the international community. The monist system, so in some countries, international law is considered to be automatically incorporated into their domestic law. So once a country becomes a party to an international treaty, blah, 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 then international law automatically becomes part of their own law, okay, pursuant to the monist theory. So they do not make a distinction between international law and their own domestic laws. Okay, so in monist systems, typically international law takes precedence over conflicting domestic law, unless, of course, the domestic constitution explicitly states otherwise. However, in dualist countries, okay, where international and domestic law are considered to be separate and distinct, okay, so in these jurisdictions, an international treaty must first be transposed or transformed into domestic legislation before it becomes valid and enforceable. So here, whether international law takes precedence is a matter of domestic law, often requiring legislative or constitutional arrangements to resolve the conflict. Then we also have to consider the harmonization rule or theory. So under the harmonization rule or theory advocates for interpreting domestic and international laws in a way that avoids conflict and promotes consistency with the two legal systems. So the theory suggests that unless there is a clear and explicit contradiction between domestic statute and an international treaty or obligation, the court should always strive to interpret the statute or the domestic law in a way that would make it inconsistent or that would make it align with international law. So in some jurisdiction, this approach has been codified or adopted as general principle of law. For example, in the US, okay, in the US, the United States Supreme Court adopted or formulated what is known as the Charming Betsy Canon. Under the Charming Betsy Canon, okay, an act of Congress should never be construed to violate the law of nations if any possible construction remains available. So meaning to say, if there is an apparent conflict between international law or a norm of international law and a statute passed by the US Congress, okay, and if the statute or the statute passed by the US Congress is susceptible to two possible interpretations, one in conflict with international law and one consistent with international law. Such interpretation, which would make the statute to be consistent with international law, okay, such interpretation will have to be adopted. Okay, so that is what is meant by the Charming Betsy canon. Another consideration is the Lex Fori principle. Now, the Lex Fori principle refers to the rule that the law of the forum or the jurisdiction where the legal action is brought governs procedural matters and sometimes even substantive issues in the case. So, for example, in international forums, the governing law is typically international law. Okay, so this includes treaties, customary international law, and general principles of law recognized by the civilized nations. Specific courts like, for example, the International Criminal Court, the ICC, the International Court of Justice, the ICJ, have well-defined jurisdiction and set of laws that they apply. Okay, and these are outlined in their founding or fundamental documents, for example, the Rome Statute with respect to the International Criminal Court and the Statute of the International Court of Justice. Now, if we turn to the domestic forum, when a court in a particular jurisdiction is deciding on a matter that could be governed by either international or domestic law, the Lex Fori principle generally dictates that the court will apply its own domestic laws to the procedural and possibly substantive aspects of the case. So, however, the domestic law itself may include provisions that incorporate international law or treaties, or they may be established jurisprudential principles that guide the court in giving weight to international law. But as a default, domestic law shall apply, subject to the exceptions that might compel the application of international law. So this is in consideration of the fact, for example, under Philippine law, okay, the Constitution in Article 2, Section 2 provides that, okay, we adopt the generally accepted principles of international law and, we make them part of the law of the land. So technically, under the Lex Fori principle, if the matter, the issue, the conflict, the apparent conflict between international and domestic law is to be decided by domestic court, the domestic court also has to take into account that international law, particularly the generally accepted principles of international law, are also deemed to be part of the law of the land. Okay, so technically, when we say law of the forum, it's not automatically the domestic law, which is the law of the forum, because international law principles or norms that have been incorporated or even transformed as part of domestic law likewise become part of domestic law. And so this brings us to the question. So what if there is an irreconcilable conflict between international law and domestic law? So what do we do? Okay, so first, another consideration before we can answer the question is we must distinguish between jus cogens principles or norms, okay, and jus dispositibum norms. So when a norm of international law is considered to be jus cogens, so it's an imperative norm of international law. Means it's an imperative, all states are bound, no derogation from these norms is allowed. Okay, while jus dispositibum norms are just any norm, the states may or may not adopt them. So, for example, if states are negotiating a treaty, they cannot put any statement or provision in the treaty that would put them in violation of certain jus cogens norms. However, with respect to norms which are considered to be merely jus dispositibum, they may or may not adopt those norms, okay, as part of their agreement or stipulations in their treaty or convention. So, jus cogens norms being the most supreme of all norms, being imperative, and whereby states do have the obligation not to derogate upon them or not to derogate them. Okay, so in case of conflict between jus cogens norms and domestic law, okay, so that's not a complicated problem because obviously jus cogens norms will prevail. Okay, now what if the conflict is between a treaty? Okay, now let's look at this from the lens of Philippine law and jurisprudence. So if the conflict is between a treaty and our own constitution, so how do we how do we handle or address the situation? Now, take note, Article 27 of the Vienna Convention on Diplomatic Relations. Okay, a party. No, I'm sorry, there's a typographical error. It should be the Vienna Convention on the Law of Treaties. A party may not invoke the provisions of its own internal law as a justification for its failure to perform a treaty. However, this is without prejudice to Article 46 of the Vienna Convention on the Law of Treaties. Okay, and Article 46 says that the state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of a provision of its own internal law regarding competence to conclude treaties as validating its consent, unless that violation was manifest and concerned a rule of its internal law, which is of fundamental character. Now, sorry. So, while as a rule, okay, in the point of view of international law, whenever there's a conflict between a treaty, we cannot be excused from the performance of our obligations under treaty by invoking our own internal law. However, Article 46 specifically allows that when we are invoking, okay, when the violation was manifest and it concerns a rule of internal law which is fundamental importance, and that refers to a constitutional provision or the Constitution in general. Okay, so when that happens, okay, we are actually allowed to deviate from our own treaty obligations. Now, what if the conflict is between treaties, and statutes? So what happens? So first consideration, take note of Article 7, Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all members of the Senate. So this implies that once the Senate provides its concurrence, the treaty becomes part of the domestic law and it can be enforceable within the Philippines. However, you should also consider that or determine if the treaty or its provisions are self-executory or not, because treaty provisions can also be self-executory or not self-executory. So non-self-executory provisions in a treaty would require legislative enabling acts, okay, in order for them to be implemented and to be enforceable in the Philippines. Okay, and then also take note of Article 8, Section 5 of the Constitution, which gives the Supreme Court the power to review, revise, modify, reverse, modify, or affirm on appeal or certiorari. As the law, the rules of court may provide final judgment and orders of lower courts in all cases in which the constitutionality or validity of any treaty, international or executive agreement is in question. Okay, so this means that, okay, Supreme Court may decide on cases involving constitutionality or validity of treaties or international agreements, implying therefore that the Supreme Court may declare a treaty unconstitutional in the point of view of Philippine law. However, you have to take note that in the point of view of Philippine law, even if we declare a treaty unconstitutional, it may not automatically excuse us from our obligations under international law. So as we have mentioned, okay, as a rule, we cannot invoke our own domestic law unless, of course, you can argue that, okay, the principle being violated by the treaty is so fundamental, okay, that it must be respected over the enforcement of the treaty. Another consideration is the ruling of the Supreme Court, the statements made by the Supreme Court in the case of Ichong versus Hernandez, whereby the Supreme Court said that the police power may not be curtailed or surrendered by any treaty or any other conventional agreement. Okay, Supreme Court said that a treaty is always subject to a qualification or amendment by a subsequent law, okay, and the same may never curtail or restrict the scope of police power. Okay, now take note, in a recent decision in Pangilinan versus Cayetano, it was qualified, it was specified by the Supreme Court that a treaty cannot amend a statute. Okay, so a treaty cannot amend. Okay, a treaty entered into and ratified by the president, and even after being concurred by 2/3 of all the members of the Senate, okay, it cannot amend a statute. Okay, so take note, in case of conflict, okay, under the in the explanation of the Supreme Court in Pangilinan versus Cayetano, if the treaty amends a statute, there are two options available. First option, the president may unilaterally withdraw from a treaty, or the statute can be amended in order to make it consistent with the treaty. Okay, so the rule is there should be no conflict between the two. Okay, so either the president withdraws from the treaty, or Congress may amend the law, the inconsistent law, to make it consistent with the treaty. Now, what if the conflict is between customary norms, okay, which are automatically incorporated as part of the law of the land pursuant to the incorporation clause under Article 2, Section 2 of the Constitution, okay, and now they conflict with our own statutes or domestic law. Okay, so what happens? First consideration, Philip Morris versus Court of Appeals. When principles or norms of international law are incorporated pursuant to the incorporation clause, they are given a status equal but not superior to our own domestic law. Okay, so meaning say they're just equal, they're just to be treated like any domestic law. Okay, so what is the effect of that? What is the legal consequence or significance of that judgment? Okay, that they are to be treated just like domestic law. They're given, they're accorded a status equal but not superior. Okay, so first, so in case of a conflict, what happens is that we apply principles of statutory constructions, because the conflict is now between equals, okay, considered to be part of domestic law or the law of the land. Okay, so what particular principles of statutory construction can we apply? For example, we can apply the lex specialibus rule, lex specialis derogat lehi generali, means say we must distinguish which is the lex generali, okay, and which is the lex specialis. So after we determine which is the lex generali and lex specialis, then of course under the lex specialibus rule, it is the lex specialis that prevails over the lex generali. So for example, if there is a domestic law and the domestic law applies to a particular issue or matter in a general way, but the principle of international law that has been incorporated automatically as part of the law of the land pursuant to the incorporation clause is lex specialis, applies in a special manner with respect to the same matter, and therefore under the lex specialibus rule, it is the principle of international law that must be applied, okay, the lex specialis principle. Now we can also apply the lex posterior rule, okay, under the Latin maxim leges posteriores priores contrarias abrogant. So the later law, the law which is later in time, will abrogate the law, okay, which was previous in time. Okay, so you also have to distinguish, make a determination, so which is in point of time, which is the later law. So the law that is later in time will have to prevail over the law which was, okay, previous in time. Now, another important concept that we must remember is the distinction between a treaty and an executive agreement. Now, is there a distinction between a treaty and an international agreement? Now, the distinction between the two is actually purely constitutional, and it has no international legal significance. In the point of view of international law, there is actually no difference between treaties and international agreements, okay, with respect to their binding effects upon states. Okay, they are both binding. They're all both binding on states. Okay, concerned on states concerned, as long as the negotiating functionaries or the representatives of the states which participated in their negotiation and conclusion have have remained within their powers. Means say they have remained within the bounds of their authority and have not acted in an ultra vires manner. The Vienna Convention on the Law of Treaties also does not make a distinction between executive agreements and treaties. An international agreement that meets the requirement of the definition of a treaty is recognized as a treaty whatever its particular title or designation is given by the states. So states can call it whatever, okay, but in the point of view of the Vienna Convention on the Law of Treaties, as long as it fits the definition of a treaty, then it will be considered a treaty, okay, within the context of the Vienna Convention. Okay. Now, if we turn to Philippine law, okay, we distinguish between a treaty and an executive agreement. As to conclusion, Philippine law, particularly our Constitution, requires that a treaty is concluded by the President with the advice and consent of the Senate. Okay, so particularly Article 7, Section 21 requires that no treaty or international agreement shall be valid and effective unless concurred by at least 2/3 of all the members of the Senate. On the other hand, an executive agreement is concluded by the President based on authority, either granted by Congress or an inherent authority granted to the President by the Constitution itself, or an authority which is inherent in the office of the executive. Now, as to subject matters, treaties are commonly used for matters of political or national character, such as peace and friendship agreements, alliances, boundary disputes, okay? Whereas international agreements are commonly used for matters of purely executive and administrative concerns, such as adjustments in commercial or consular relations between states. Now, with respect to their binding effect, okay, so executive agreements result in binding international obligations. Okay, so as I mentioned, they are valid and binding under international law. Okay, and recently in the 2021 case of Pangilinan versus Cayetano, the Supreme Court ruled that the validity and effectivity of executive agreements are contingent on their traceability to an express or an implied authorization to an express or implied authorization, okay, under the Constitution or the statutes or other treaties. So, in effect, executive agreements must not create new international obligations, okay, not expressly allowed or reasonably implied by law that they purport to implement. So, the absence of these precedents puts the validity and effectivity of an executive agreement under serious question. So the main function of the executive is to enforce the Constitution and the laws enacted by the legislature, not to defeat or interfere in the performance of these rules. Therefore, while executive agreements are binding at the international level, their domestic effect is subject to their consistency with the Constitution and as well as to enacting laws and treaties. Now, with respect to legal hierarchy, are treaties superior to executive agreements, or is it the other way around? Okay, so treaties are, by their very nature, considered to be superior to executive agreements. Treaties are products of the acts of the executive and the Senate, okay, blending of powers, unlike executive agreements, which are solely executive actions. So because of legislative participation through the Senate, a treaty is regarded as being on the same level as a statute. So if there is an irreconcilable conflict, a later law or a treaty takes precedence over one that is prior. So an executive agreement is treated differently. Executive agreements that are inconsistent with either the law or a treaty, okay, will be considered ineffective. But of course, you have to take note that both treaties and executive agreements, of course, are subject to the supremacy of the Constitution. So there is no difference in that regard. Now, another important source of bar exam questions is the concept of diplomatic immunity and the concept of consular immunity. Now, you have to be very clear about the distinctions between these two. Okay, so with respect to criminal jurisdiction, diplomatic envoys shall not be liable to any form of arrest or detention, and they shall enjoy immunity from the criminal jurisdiction of the receiving state. Okay. Now, with respect to consular officials, they shall not enjoy immunity from criminal jurisdiction. Meaning to say, if criminal proceedings are instituted against a consular officer, he must appear before the competent authorities to defend or represent himself. Okay. They shall not, however, they shall not be liable to arrest and detention pending trial, except in case of a grave crime and pursuant to a decision of a competent authority. Now, as to civil jurisdiction, diplomatic envoys shall enjoy immunity except in the following cases: a real action relating to private immovable property situated in the territory of the receiving state, in an action relating to succession in which they are involved as a private person, not on behalf of the sending state, or in an action relating to any professional or commercial activity exercised by the diplomatic envoy in the receiving state outside of their official functions. Consular officials, on the other hand, shall also enjoy immunity from civil jurisdiction except in respect of civil actions, either, okay, number one, arising out of a contract concluded by the consular official in which the consular official acted in his personal capacity, or when he is there is an action by a third party for damages or arising from an accident in which the receiving state okay, caused by a vehicle, a vessel, or aircraft in the receiving state. So basically, you have to be clear about this. So diplomatic envoys, with respect to criminal actions, they are entitled to complete immunity from criminal jurisdiction. However, it doesn't mean, of course, that they are completely free to commit any crime. Okay, if they commit any crime within the territorial jurisdiction, the receiving state, they shall be immune only from the criminal jurisdiction of the receiving state. But of course, they are not immune from the jurisdiction of their own sending state. Okay, so meaning to say, while we cannot take jurisdiction over them, okay, for the commission of any crimes within the territory of, for example, the Philippines, okay, it doesn't mean that they will be excused or exempted from criminal liability, because they will be subject to trial and punishment within or pursuant to the laws of the sending state. Now, with respect to treaty withdrawals, okay, so you have to take note that the president's power or discretion on treaty withdrawal is not absolute. Okay, so his discretion to unilaterally withdraw from any treaty or international agreement, okay, is not absolute. Okay, so this was clarified again by the Supreme Court in the case of Pangilinan versus Cayetano, whereby the Supreme Court said that the president's power to withdraw from international treaties is subject to constitutional framework and to the rule of law. And moreover, the president's power to withdraw from a treaty is limited by the need to respect the legislative process and the principle of separation of powers. So when can the president unilaterally withdraw from a treaty? So take note, the 1987 Constitution does not explicitly provide for the process of withdrawal from international treaties. However, it does provide that in the process of treaty ratification, particularly in Section 21, Article 7, okay, so no treaty of international agreement shall be valid and effective unless concurred by at least 2/3 of all the members of the Senate. So this provision implies that the Senate's concurrence is necessary for the validity and effectiveness of a treaty or international agreement. However, in the case of Pangilinan versus Cayetano, the Supreme Court clarified that the president cannot unilaterally withdraw from a treaty if there is a subsequent legislation which affirms or implements a treaty. Conversely, a treaty cannot amend a statute. Okay, so as previously mentioned, so when the president enters into a treaty that is inconsistent with the prior statute, So either the president unilaterally withdraws from the treaty, or the prior statute can be amended by Congress to be consistent with the treaty. And therefore, the extent of legislative involvement in withdrawing from treaties is determined by circumstances attendant to how the treaty was entered into or how it came into effect. Okay, so where the legislative imprimatur impelled the president's action to enter into a treaty, a withdrawal cannot be effected without the concomitant legislative sanction. So similarly, where the Senate's concurrence imposes a condition, a condition on the same concurrence for withdrawal, so the president enjoys no unilateral authority to withdraw and must therefore secure the concurrence of the Senate prior to withdrawing from a treaty. Okay, so does the president can withdraw from a treaty as a matter of policy in keeping with our legal system if the treaty is unconstitutional or contrary to provisions of an existing law. However, the president may not unilaterally withdraw from a treaty when the Senate conditionally concurs, such that it requires concurrence also to withdraw, or when the withdrawal itself is contrary to a statute or to a legislative authority to negotiate and enters into a treaty or an existing law which implements a treaty. So as requested by Rex Education and Philippine Association of Law School, I need to end the lecture by 4:30, so it's 4:29. So it's exactly right in time.
All right. Thank you very much, Dean, for your comprehensive and insightful lecture for today. Now, for everyone, we are opening the floor for any questions. You can send them via the comment feature on our Facebook Live, both on the page of PALS as well as Rex Education. Now, again, we are reminding everyone and all attendees that this lecture is streamed via Facebook Live and that recording and or reproduction of this session is neither allowed nor encouraged. So this session is readily available already on the Facebook pages of our partners, so you can replay it when needed. So you can send your questions now via comments. So sir, actually for me, I have a question. It's in relation to the president's immunity from suit during his or her term. So it's a general rule, I think, that the president is immune from suit during his or her term. But if ever there's a violation during the president's term, will that be included in counting? Will his or her term be included in counting the prescription of the crime he has committed? Say, let's say if it's an unofficial act po.
Prescription means say you're looking at the context of a violation. Let's say a criminal act was committed by the president during his term,
Yes po.
and so the statute of limitations is therefore running, and therefore
Yes.
during the time that he is considered to be immune from suit, then I would say that the statute of limitations would have to be considered as being suspended, because at that particular time, when the principle of state immunity is in effect, it does not allow the complainant to file the action, meaning say effectively therefore suspending the application of the period of prescription. So I think theoretically it must not be counted.
Okay. So also in relation then being with the power of the president, so it's also mentioned earlier that the president has a power to veto specific line items or particular items when in terms of appropriation. But is it also possible that the president can appropriate a specific lump of budget to another office or another agency?
Well, it cannot be done technically by the president, because that should be part of the appropriation law. So meaning to say, when the president exercises the veto power, he just have to veto, and he cannot transfer, one in the process of approving the appropriations law. Okay, So he has to approve the appropriations law and then exercise only his powers as limited by the Constitution. So if he exercises the line veto, then it results to a line veto. But in approving the appropriations law, he doesn't have the authority, to transfer one item to another and then make it, approve it and then make it a law. Then effectively, that would be an assumption of legislative powers because only the legislature can do that pursuant to its power of appropriation.
All right, sir. Another
Gumiling,
question.
parang pinapahirapan mo ako.
Hindi naman po. Another question naman po. Since regarding election laws naman din, we have a provision, I think it's called the lame duck provision, where it is prohibited to appoint.
Dapat siguro mag-decide ka, ikaw siguro mag-answer.
I would just like to ask po if it is also applicable to the officially withdrawn candidates of the previously held elections po.
I would say I am not I cannot answer that question specifically. It might be subject to a specific provision or decision of the Supreme Court of which at present I am not aware. So I'm sorry about that.
That's okay po din. So, seeing that there are no other questions, both from the Rex page as well as the Pulse page, I think they have already understood your lecture na din. So, let me ask you po for final words of encouragement or for our baristas for our upcoming bar. So, konting araw na lang po din. Bar exam na.
Oo nga, no? So, well, ganun lang. Good luck. And I hope you would use the remaining time, to your benefit. Okay, do not waste the remaining time. Okay, it's in every hour towards the the week, no? Kasi practically 1 week na lang is very important. So you must be sure that you use it to your advantage. I usually say that you must study actively. Okay, anything that you do, especially towards this last week of the bar, should be beneficial or should enhance your chances to be admitted to the honorable profession of lawyers. So good luck. I hope to see you at the oath taking. There are several bar exam sites. Of course, we cannot go around. Okay, so for example, in my case, most of my students are in Cebu City, so I'll be going to Cebu City for our bar operations. So for those who are in students or bar takers here from Cebu City, okay, I hope I can say hi to you. But for those who are in other bar examination sites, so I'm sure and I hope that I will see you during the oath taking.
All right. Thank you very much, Dean Sarmiento. And I'm very sure that our baristas, as well as those who have attended here, including myself, have learned a lot from your lecture in political law as well as international law. So now we are reminding everyone of the following schedule of the remaining lectures for the pre-week for 2023 bar examinations. We have taxation law on September 11, then criminal law on September 12, and remedial law focusing on evidence on September 13. Of course, this event will not be possible without our ever-supportive sponsors and partners. We extend our deepest and sincerest gratitude to the Philippine Association of Law Schools and Rex Education. Once again, thank you very much, Dean Ralph Sarmiento, and to everyone who participated and attended today's session.